Let me say something that is going to make a lot of people uncomfortable. Your concealed carry permit, the one you paid for, trained for, and waited weeks to receive, may not protect you the way you think it does. Not anymore. Because the Supreme Court just handed down a decision that is quietly rewriting the rules of how you carry, where you carry, and what happens the moment a police officer asks you about your firearm. And I mean quietly. The mainstream media is covering the headlines, but nobody, and I mean nobody, is sitting down and walking you through exactly what this means the next time you get pulled over, the next time you cross a state line, or the next time law enforcement shows up at your door. That stops today. In the next few minutes, I am going to walk you through what the court actually decided. I am going to explain a legal tactic being used in states across this country that is specifically designed to make your permit useless, without ever passing an explicit gun ban. I am going to walk you through what this means at a traffic stop, at your front door, and in a formal investigation. And I'm going to give you a clear, specific action plan so that you walk away from this more protected than you were when you started watching. Now, let us talk about what you have probably already seen this week. Your social media feed is flooded with headlines. Some scream that the Supreme Court destroyed gun rights. Others say gun rights were saved. Everything is changing. Nothing is changing. Here is the truth about every single one of those headlines. They are written to make you feel something and click something. They are not written to make you understand something. And understanding something is the only thing that actually protects you. So here is what we are going to do differently. We are going to go straight to the source. We are going to look at what the justices actually wrote and what that language means in the real world. Not in a law school classroom, not in a political debate, but in your car at 11 o'clock at night, when a flashlight is shining through your window and you have a legally owned firearm in your center console. That is the moment where knowing the law, or not knowing it, defines the rest of your life. So what actually happened at the Supreme Court? The case centers on a question that sounds simple, but is anything but. When can the government restrict a law-abiding citizen's access to firearms based on a civil court proceeding rather than a criminal conviction? Read that again carefully. Civil court, not a criminal trial, not a jury. A civil proceeding where the standard of proof is lower, where the process moves faster, and where you often do not even get a chance to speak before a decision is made about your rights. For years, this was a legal gray zone. Some courts said civil orders were sufficient to strip your gun rights immediately. Other courts said, no, you need something more before the government can remove constitutionally protected rights from a citizen. A gun owner in Texas was operating under completely different rules than a gun owner in Massachusetts. The law was supposed to be uniform because it was federal law, but the interpretation varied wildly depending on which judge you drew. The Supreme Court stepped in to settle it, and here's the core of what they said. The Second Amendment does not exist in isolation. It sits alongside the Fifth Amendment. It sits alongside the 14th Amendment. And those amendments say something very clear. The government cannot take your liberty. The government cannot take your property without due process of law. Your firearms are property. Your right to carry is a liberty interest. That means before either one is touched, the government owes you a process, a real process. Not a rubber stamp, not a hurried signature from a judge who spent 4 minutes on your file. A genuine, constitutionally sound process where your side of the story actually counts. That is what this ruling reinforced. And the ripple effects are larger than most people realize. Here is where it becomes important in a way that applies to your life right now. This week, most of the coverage is focused on the domestic violence angle because that is what the case directly involved. But the legal principles the court laid out go far beyond domestic situations. Legal scholars are already writing about this. Defense attorneys are already thinking about how to apply it. Because the court did not just rule on one narrow factual situation. They established a framework, a set of principles about what the government must do before restricting Second Amendment rights. Think about red flag laws. Right now, 19 states have red flag laws on the books. These laws allow someone, a family member, a coworker, sometimes even law enforcement, to petition a court to seize your firearms based on a perceived threat. Not a crime, not a conviction, a perceived threat. In many of these states, your firearms are gone before you ever walk into a courtroom, before you ever see the evidence against you, before you ever get to say a single word in your own defense. Under the principles this court just laid out, that process is now on very shaky legal ground. The court said clearly that the state must provide meaningful process before stripping constitutional rights. Meaningful process. Not a rushed hearing, not a one-sided presentation. That single word, meaningful, is going to be argued in courtrooms across this country for the next decade. If you live in a red flag state, the legal ground beneath those laws just shifted. Court challenges are coming. Some of those laws may be struck down entirely. Others will have to be rewritten to meet the new standard. You need to know if your state is one of the ones already facing these legal challenges. Because the law you are following today might not be the law that exists tomorrow. But here is something that almost nobody is covering, and it connects to this ruling in a direct and dangerous way. A number of states are actively using a legal tactic that experts have started calling the default ban approach. Under traditional American law, if you have a concealed carry permit, you are allowed to carry your firearm into businesses open to the public. If a business owner does not want firearms on the premises, they post a sign. The default was freedom. You are a law-abiding citizen until told otherwise. Several states flipped that completely on its head. They passed laws stating that it is automatically a crime to carry your firearm onto any private property open to the public, unless the owner has explicitly posted a sign saying firearms are permitted. They changed the default setting from freedom to prohibition. Your constitutional right to self-defense is effectively banned the moment you step onto private property. A grocery store, a gas station, a bank, unless that property has specifically invited it. Think about what that means in practice. Imagine driving home from work on a Tuesday evening. You stop to grab milk. You have your lawful concealed carry permit. Your firearm is securely holstered. Under this approach, the moment your foot crosses the threshold of that store, you have potentially committed a serious crime. Because the store owner did not post an invitation sign. It does not matter that you are a peaceful, law-abiding citizen who passed multiple background checks. The state has decided your right to protect yourself stops the exact moment you try to buy groceries. This creates a hidden minefield for responsible gun owners. It forces you to constantly scan windows for signs that may or may not exist. It leaves you defenseless in parking lots, the exact locations where many violent crimes actually occur, while you try to determine whether you are legally permitted to walk inside. And it is specifically designed to make your permit practically useless without passing an outright ban that would immediately be challenged in court. When prosecutors and state attorneys tried to defend these kinds of restrictions, they ran into a wall. They could not find a single historical law from the founding era that banned law-abiding citizens from carrying common defensive weapons into public businesses. In fact, early American history shows the exact opposite. People carried firearms routinely as they went about their daily commerce. The framework this court reinforced is clear. If the government wants to restrict your Second Amendment rights, they must prove that their restriction aligns with the historical tradition of this country. They cannot simply invent new restrictions because they disapprove of firearms. That is the standard, and that standard matters every single time one of these new state laws is challenged in court. Now let us talk about something that connects directly to this ruling in a way nobody is explaining properly: the Fourth Amendment. Most gun owners have a general sense of what the Fourth Amendment covers: unreasonable searches and seizures. You need a warrant. But the details of how this applies when you are actually carrying are where things get complicated. Here's the scenario you need to think through carefully. You are driving home. A police officer pulls you over for a minor traffic violation, a taillight, a rolling stop. The officer approaches and the conversation starts normally. License, registration, and then the question: do you have any weapons in the vehicle tonight? Most concealed carriers answer immediately. They say yes. They say where it is. They hand over their permit without being asked. They think transparency will make the stop go smoother and get them home faster. Sometimes that is true. I want to be fair about that. But here's what the law actually says about that moment. You have a Fourth Amendment right against unreasonable searches and seizures, and that right does not disappear because you happen to be sitting in a car. The Supreme Court has been consistent about this for decades. Your vehicle is your property. An officer needs either a warrant, your consent, or a specific legal exception to search it. When you voluntarily disclose the location of your firearm, you have not consented to a search. But you have, potentially, provided the officer with information that changes the entire dynamic of the stop. Information that might lead them to claim a reason to look further. Information that you had no legal obligation to provide in the first place. The framework this court reinforced strengthens the argument that your rights are continuous. They do not pause at a traffic stop. They do not take a break because you feel social pressure to cooperate. You can be respectful, you can be calm, and you can still say, "I am not consenting to a search of my vehicle." Those words are not aggressive, they are constitutional. And under the framework this court just reinforced, they are more protected than ever before. But there is another layer to this that is even more important: the Fifth Amendment. People hear Fifth Amendment and they think courtroom. They picture a defendant on the stand refusing to testify. But the Fifth Amendment is not just a courtroom protection. It is an every single day of your life protection. It applies when a detective calls and says he just wants to chat. It applies when an investigator knocks on your door and says it is just routine. It applies when a form asks you a question that could later be used against you. The right against self-incrimination is not something you invoke after you are already in trouble. It is something you use to make sure you never get into trouble in the first place. Here is a scenario that will make this concrete. You have a neighbor. There is some tension, maybe a property dispute, maybe noise. He calls the police, mentions that you own firearms, and says he feels threatened. 2 officers show up at your door. They are polite. They say they just need to ask a few questions. They say this will only take a few minutes. They say if you have nothing to hide, talking to them will clear everything up quickly. Every single one of those statements is designed to get you talking. And the moment you start talking without an attorney present, you are at risk. Not because you are guilty, not because you did anything wrong, because words are flexible. Memory is imperfect. Context can be stripped away, and anything you say can and will be used against you if the situation escalates. The legally correct move in that scenario is straightforward. You step outside, you close the door behind you, and you say, "I want to be cooperative, and I am happy to speak with you, but I would like to have my attorney present first." That is the entire move. You have not been rude, you have not been aggressive, you have exercised a constitutional right that exists specifically to protect people exactly like you in exactly that situation. Now let us talk about the state-level landscape, because this is something every concealed carrier needs to understand urgently. And the Supreme Court ruling alone cannot fix it. Here is a reality check that most gun content never addresses honestly. The legal environment you are carrying in today is not static. It is a living system. And parts of that system are actively working against you right now. Not in a theoretical sense, in a concrete legislative courtroom sense. Bills are being drafted, enforcement guidance is being updated, prosecutors are developing new charging strategies. The legal landscape you learned when you got your permit may have already shifted in ways that directly affect your daily carry decisions. That is not meant to frighten you. It is meant to motivate you to stay current. Because staying current is the only real protection you have in a system this dynamic. Federal rulings set the floor. They establish the minimum standard of protection every state must meet. But states test that floor constantly. They write new laws designed to operate right at the edge of what is constitutional. Sometimes they go over that edge and wait to be challenged. And while they are waiting to be challenged, the law is on the books. If you violate it, you face the consequences, even if that law is later found unconstitutional. This is the trap that catches good, careful people. Right now, states are actively drafting legislation in response to this ruling. Some are trying to find new approaches that appear to comply with the new due process standard on the surface, while still moving quickly against gun owners. They have attorneys working on it. They are not giving up simply because the court issued a ruling. Other states are moving in the opposite direction, using this ruling to expand carry rights and challenge permit requirements that may not survive constitutional scrutiny under the new framework. The result is a patchwork, a legal landscape that changes depending on which side of a state line you are standing on. And that patchwork is becoming more complicated every single month. If you travel between states with your firearm, and many of you do, you cannot assume that what is legal at home is legal everywhere you go. You cannot assume your permit is recognized. You cannot assume your carry method is compliant. You have to know the specific laws of every state you drive through, every state you stop in, every state you spend the night in. That is not paranoia. That is the current legal reality. The Firearm Owners Protection Act gives you some federal protection when traveling through states where your firearm would otherwise be illegal. But that protection has specific conditions and strict limits that most people have never actually read. And without a valid, state-recognized permit, a routine drive that takes you within 1,000 feet of a school can trigger the Federal Gun-Free School Zones Act, a federal felony. Constitutional carry is a significant victory, but it has very specific geographical limits that most people do not fully understand until it is too late. There is also something almost nobody in this space is talking about that connects directly to the Fourth Amendment issues this ruling raises: your digital life. Think about everything on your phone right now. Your location history. Every place you have been for the past 3 years, mapped and timestamped. Your messages, your emails, your search history, photos with embedded location data. The Supreme Court ruled in Carpenter v. United States that police generally need a warrant to access your location history from phone carriers. That was a meaningful Fourth Amendment victory, but that ruling has limits, and technology has moved faster than the legal framework surrounding it. If you are ever the subject of an investigation, even one that goes nowhere, even one based on a false report, your digital footprint becomes part of the picture. Under the principles reinforced by this ruling, the argument for stronger warrant requirements on digital data becomes stronger. Defense attorneys are already connecting these dots. But do not wait for the courts to protect your digital life. Protect it yourself. Be thoughtful about what you put in writing. Be careful about what you store on devices that could be accessed. Treat your phone the way you treat your firearm, with respect for its power and full awareness of its risks. Now let me tell you about the single biggest mistake I see gun owners make over and over again across every background and experience level. They wait. They wait to learn the law until they need it. They wait to save an attorney's number until they are already in handcuffs. They wait to have the family conversation until after something has already gone wrong. They wait because nothing bad has happened yet, and because they are careful and responsible. And surely that is enough. It is not enough. Careful and responsible people get caught in legal situations they did not create. Careful and responsible people have false reports filed against them. Careful and responsible people get pulled into investigations that start with someone else and somehow expand to include them. Preparation is not for people who are planning to do something wrong. Preparation is for people who understand that the world is unpredictable and that the law does not always move the way it should. The gun owners who come out of difficult legal situations intact are not just lucky. They are prepared. They knew their rights. They had an attorney's number saved. Their family knew what to do. They did not panic at the worst possible moment because they had already thought through what that moment might look like. This brings me to something that very few people in this space ever discuss, and I think it is one of the most important points in this entire conversation. This does not just affect you. If you have a spouse, think about them right now. If you have adult children living in the house, think about them. If there is anyone else in your household, think about them. Because if a protective order is filed, if a red flag petition is submitted, if any legal action targeting your firearms begins, every person in that household is affected. Their access to firearms they legally own may be restricted. Their privacy may be compromised through the process. Their daily life is disrupted the moment that legal process begins. Most families are completely unprepared for this possibility. They have not had the conversation. They do not know what to do if officers come to the door and the gun owner is not home. They do not know whether to allow entry. They do not know what to say. They do not know who to call. That gap in preparation is dangerous, because in those first few minutes of a legal confrontation, decisions get made that cannot be undone. Words get said that cannot be taken back, and evidence gets created that cannot be erased. This ruling, with its emphasis on process and fairness, gives you time. If the new standard is applied correctly, you should have more notice before action is taken against you, more opportunity to prepare. Use that time. Here's what I want you to do this week, not someday, this week. Sit down with your family and have the conversation. Tell them that if law enforcement ever shows up and you are not home, they are to be polite, step outside, close the door, and call you and your attorney immediately. No exceptions. No matter how friendly the officers seem, no matter how routine they say it is, that conversation could be the most important one you ever have. The founders were not naive people. They had just lived through a government that used legal mechanisms to suppress rights. They had seen how quickly a process that sounds fair can be twisted into something that is anything but. They had seen how accusations become convictions and how power flows to those who control the process. So they built protections. multiple layers. The Second Amendment, to guarantee the right to bear arms. The Fourth Amendment, to protect your home and property from government intrusion. The Fifth Amendment, to ensure you could never be forced to participate in your own legal destruction. The 14th Amendment, to extend these protections against state governments as well as the federal government. These were not accidents. They were intentional architecture, a system designed to make it genuinely difficult for the government to harm the people it is supposed to serve. What this Supreme Court ruling does at its core is reinforce that architecture. It says the protections the founders built are still standing. They still mean what they were meant to mean, and the government still has to work within them. That is worth something. That is worth a great deal. But the founders also understood something else. Rights without knowledge are not really rights at all. If you do not know what you are protected from, you cannot protect yourself. If you do not understand the process, you cannot navigate it. If you are ignorant of the law will be used against you regardless of your innocence. So let me give you a clear, specific action plan to take away from this. First, review your current permits today. Make sure they are current and fully compliant with your state's latest requirements. Do not assume that because they were valid 6 months ago, they are still valid in exactly the same way. Requirements change. Renewal windows shift. Getting caught with an expired or non-compliant permit is an entirely avoidable problem. Second, research reciprocity for every state you travel through. Do not carry across state lines without knowing exactly what you are walking into. Use a current reciprocity resource and verify that it is actually current. A map that was accurate 6 months ago may not reflect legislation that passed last month. Third, find a Second Amendment attorney in your area and save their number in your phone right now. Not a general practice attorney, someone with specific experience in firearms law who knows this area deeply, knows your state's courts, and understands how local prosecutors approach these cases. That 10-minute investment today could be worth more than everything else you have ever done for your legal safety as a gun owner. Fourth, have the family conversation tonight if at all possible. Everyone in your household should know what to do if law enforcement comes to the door, that they should never consent to a search, and that the first call they make should be to you and your attorney, not an attempt to explain or negotiate on their own. Fifth, stay informed. Not through headlines, not through social media panic, through sources that actually read the opinions, explain what they mean in plain language, and track state legislation to tell you when something changes that directly affects your rights. The Second Amendment is not self-executing. It does not protect itself. It does not enforce itself. It does not explain itself to the officer shining a flashlight through your window at night. You protect it by knowing it, by exercising it correctly, by understanding the full framework of rights that surrounds it and supports it. This Supreme Court ruling is a step in the right direction. It reinforces due process. It raises the bar for what the government must do before it touches your rights. That is genuinely good news, worth acknowledging and worth understanding deeply. But one ruling does not end the fight. It shifts the battleground. And the next battles are already forming in state legislatures, in lower courts, in enforcement policies, and in the quiet decisions being made by officials who are hoping you are not paying attention. Pay attention. Stay informed. Stay legal. Stay prepared. This content is for educational purposes only and does not constitute legal advice. Laws vary by state and change frequently. Always consult a qualified attorney for guidance specific to your situation.